Thank you very much. I'm delighted. I'm delighted to be here with you. It's my first time in Dublin, in fact, in Ireland. I'm looking forward to see a bit of this. Haven't had a chance yet, but I'm delighted. And even though I'm here in my personal capacity, so I'm not representing the compliance committee, I'm not representing the Aarhus bodies, but I'm sure I would express from all of us in the Aarhus family, very welcome to Ireland, to join us after so many years. We've been waiting for you to come. So I'm really delighted that I have a chance to talk to you here in Dublin on the occasion that you are inside, that you have ratified. So that's a very good news. And I'm really looking forward to cooperate further with you. So what I'm going to tell you a bit, it's first of what I've been asked to tell you. It's first of all about how it all came about. What has made up the Aarhus Convention, why it came about, why we in Europe decided to have this instrument, and what is the status and role generally both in Europe, in European Union, and globally. Then a very short overview of the operative provisions of the Convention. I'm really happy to see that you've been provided with the copies, because that's very useful to have a text with you. And then finally a bit about the compliance mechanism, which is to some extent a unique body, because it combines the features of the human rights mechanism and environmental convention compliance mechanism. So it is unique, and I will give you a very short overview of how it works. So first about the genesis, and I have had a privilege and a pleasure to be right from the beginning when the negotiations on the convention started, and I've seen it all development. So it is pretty much a personal view of the convention. But it is, on the one hand, it is new, but on the other hand, it is well rooted in some traditions. Or let's put it this way. It's well rooted in the attempts to break with the older traditions in Europe. The older traditions in Europe were about the secret. Government has information, and who has information has power. Therefore, sharing information is losing somehow a power. That was the traditional approach all over Europe. That was, to some extent, a different tradition in Scandinavia, where in Sweden in the 18th century they established an act on freedom of information for press, or press law. But in all Europe, there was a tradition of secret. And there was also another tradition that assumed that democracy is all about voting from time to time, once in a 4 year for 5 years, for your elected representatives, and that's it. And the rest is up to the officials, who are supervised by these elected representatives, but otherwise the public is not involved. So these two presumptions in Europe started to be challenged by some thinkers, some philosophers, Karl Popper and his famous concept of open society. And it really took effect in the United States, where this new approach to governance took effect, and they started to make changes to the way they governed the society. And they introduced Freedom of Information Act in 1966, which opened the government files. They introduced certain changes to the Administrative Procedure Act, whereby they assumed that all those who have any interest They should have a possibility to be heard, and the authority, the decision maker, should take due account of all the interests that were surfaced during the procedure. So these were the new ideas that took effect in the law already in the United States in the 50s, 60s, 70s. That coincided with a huge development of the so-called third sector of the society, and new ideas in general in the governments that also started to be visible in Europe. On the other hand, at the same time, 70s is a decade of environmental protection. And that will correspond to each other, because it soon be realized that you cannot possibly have effective environmental protection without the public being involved, without openness. That is this part of public affairs that especially requires a new approach to governance. Less secrecy, more involvement of the public. And this was encapsulated in the Principle 10 of the Rio Declaration. As you know, there was a conference in Rio de Janeiro back in 1992 where the heads of state started to think how to save the Earth from, or how to address the challenges, the global challenges. They signed a Biodiversity Convention, they signed a Climate Change Convention, and the third important piece of legislation that they adopted in Rio, there was the Rio Declaration. It is not a binding piece of legislation. It is so-called soft law, political declaration. But it's of utmost importance for countries all over the world for setting the policy goals in environmental policy. And part of this is this Principle 10 that addresses, first of all, the openness, secondly, public participation in decision-making, and thirdly, the third pillar, which is access to justice. As I said, that was a political declaration. It was not a piece of binding legislation. Following these policy trends, also in a number of international treaties, they started to mention here and there about the need for more openness, about the need for access to information, about the need for getting the public involved in decision-making. But they were just general declarations, without any procedures, without any details. More details were included in the community law at that time, already in the end of the 80s. In the European community, they started to see the challenge of opening the society. And they saw the experience with the United States, whereby they opened all the governmental files with the Freedom of Information Act. But Europe was not ready at that time to open all governmental files. But what they realized, it is possible in this new area of environmental protection. They said, okay, we will still keep all our governmental shelves closed, except for one shelf with environmental matters. And that's how they adopted a directive in the 1990 on access to environmental information. So as opposed to the United States and Scandinavian countries and some other countries in the world that already had a general access to information, to public information laws, in Europe the decision was we will open only environmental information. Then also, as far as public participation is concerned, there were two pieces of legislation already in 1985, again following the US experience with NEPA, National Environmental Policy Act. They decided that it should be public participation in the process of environmental impact assessment for projects, individual projects. And they also decided later on, here following a bit of experience in Germany, where already in 19th century, there were some provisions for public participation in industrial permitting. So there was introduced a piece of legislation on integrated pollution prevention and control, and this directive required also in all member states to have public participation in granting pollution permits. So that was in the old member states, in the community. Roughly at the same time, that started in the 90s, the democratization, collapse of the Berlin Wall, you all know this, that opened the societies in the East. So old member states started to think, if we have some experience with openness, with public participation, and it's good, it works well for the environment, why also these people in Central Europe and Eastern Europe or further down east, they shouldn't have exactly the same. So they opened the process, and that was called Environment for Europe. It was initiated by a Czech minister for the environment who thought that environment minister for all of Europe should work together because we have one European environment. So within this larger process, they decided to have to start negotiations on a binding piece of legislation that would bring about the experience from the European community, and in fact modeled after American inventions. In the meeting of ministers in Sofia, there were adopted guidelines, which was just a piece of declarative language, political soft law declaration, guidelines, but also they decided, unexpectedly I must admit, because it was ad hoc decision of the ministers, we should start negotiations on a binding piece of legislation. And they gave a mandate. Originally, the mandate was limited to only access to information, environmental information, and public participation. They were not clear whether they would like to have a binding piece of legislation related to access to justice. Because environment ministers, they didn't like so much to be confronted with the justice ministers, which inevitably, if the piece of legislation would address access to justice, that would need at home discuss it with the colleagues. And they all are a bit afraid of lawyers, you know, that lawyers are very nasty usually, and so I'm telling this being a lawyer myself, obviously. But so they were very reluctant to do this. So there was a mandate, and there was a political decisions that, first of all, there was a small group of 8 persons consisting of people with different background to produce the first text, so that the negotiators, when they sit in the negotiating table, they are not starting from the scratch, but they have some piece of text to negotiate. So I had a privilege to be one of these groups, and we provided the first text of the convention. It was very limited. On the other hand, it was a collection of different ideas. What was important that the chair was a very experienced Dutch negotiator, Willem Kakebeke. I had the privilege to be vice chair, so I was observing his skillful and very wise way of negotiating. However, what was important, he himself, but obviously that was a political decision of from political bodies, he admitted to the negotiating table also the representation of civil society, represented by NGOs. So for the first time, they were sitting at the negotiating table. I was negotiating on behalf of Polish government. There were negotiators from all the governments, but among us, there was, with full rights, a representation of NGOs, which, by the way, was chaired by a compatriot, Jeremy Waits, Irish citizen. So there was a representation of NGOs, and they were having all rights to submit proposals, to participate in discussions. Obviously, at the end of the day, the decision was to the governments. The negotiating process was difficult because the original position of the old member states of the EU was, we have pieces of legislation already, and this is all about bringing this to the East. So we are all fine. It's just to make this what is applicable to the European community, to make it applicable to whole Europe. And mind you, this UNEC, United Nations Economic Commission for Europe, is not only Europe in a strict sense. It covers, this region covers also North America, and it covers former Soviet Union, so that now it's Central Asia, Caucasus, Russia, and other countries. So that was the original approach of the EU. Americans, right from the beginning, said that's all European stuff. It's a EU background. We are not going to interfere. Later on, they regretted very much this decision. But that was the original decision. So the EU was the leading, I mean, not yet EU, at that time it was the European community. It was the leading force at the negotiating table. And as I said, the European community, the old member states, they said, it is nothing more than just bringing what we have already to the East. But that soon turned out not to be the case because, first of all, NGOs, they were bringing their own ideas. Secondly, some countries have had some experience with the already existing laws. Some of them have had more than the EU or the EC legislation required, the directive required, and they wanted to promote it. They said, it's good, it works very well in our country, why not putting this as a binding scheme? So that all created an atmosphere where we ended up with much more than was originally thought it would be. We adopted this in 1998 in the Danish city Aarhus during the ministerial conference, and soon we gathered a required number of ratifications so that it entered into force in 2001. First of all, as I said, it was more than it was originally envisaged because we all as negotiators, we were convinced that following the Rio Declaration principle 10, you cannot limit binding instrument to only two pillars, access to information and public participation. You need to have legal guarantees that if your rights are infringed, you need to have a recourse to court. So you need to have the third pillar. So it was agreed we will have access to justice. Second issue, we also were sure that as opposed to the existing legislation in the European community, which was limited to public participation at the lower end of the decision-making chain, where decisions related to specific activities are taken, that this is too late in the decision-making, that you need to have public participation at strategic decisions, policies, plans, programs, even legislations. That was acknowledged, and it was introduced to the convention, albeit the legal scheme for participation at different levels of the steered decision-making is different. The governments were not prepared to put into legislation too many details for public participation at the higher level of decision-making. During the negotiations, there was another issue. Most of the governments of the European community were quite convinced that the obligation should be put not only on them, but also on the officials of the European Commission and other community bodies. Why only our shelves should be open? Why not shelves of the European Commission? So it was added that the provisions of the convention would apply equally to governmental officers in the member states of the EU, and obviously to other parties, but also to European institutions. There were two particularly contentious issues during the negotiations. One was the issue of PRTR, that's Pollutant Release and Transfer Registers. That's, again, American invention. Americans, following certain industrial accidents, introduce a requirement that polluters should report their emissions to the publicly available database, and they created something which was called TRI, Toxic Release Inventory, which is a database in which everyone could check what sort of pollution into air, water, airs is being introduced every year by biggest polluters. And that was considered to be a useful tool for environmental policy. OECD, which represented the most developed nations, recommended this. So it was brought up under the convention that maybe we would put these recommendations, political recommendations, in a binding form. However, at that time, the governments were not ready with this. So we put only some enabling clauses, or enabling clauses in the international jargon means that if the countries cannot agree on something, they say, we will come back to this. And that's what we did later on. And we started another negotiations on the protocol on PRTR, Pollutant Release and Transfer Registers, that was later on adopted. Another contentious issue was about public participation in decisions relating to genetically modified organisms. And again, it was the same situation. The governments were not ready yet to accept that there should be mandatory public participation in these decisions. They considered this as too technical a process, and they didn't see any role for the public to be involved. And again, the same happened, that there was a promise to come back to the negotiating table, and again, it was concluded with the so-called GMO amendment to the convention. So what is the outcome? First of all, that the convention has a rights-based approach. It is similar to human rights conventions, much more than to another environmental conventions, which are very technical, and another conventions, environmental conventions, address obligations of government towards the government. Here in Aarhus, we have obligations of governments towards the public. And another issue which is precedential, which is not clearly mentioned here, is that it is not only the obligation of governments towards their own public, but an obligation towards the public at large. Because we included in the convention a non-discrimination clause, which assumes that the public should be treated equally, regardless of what is their citizenship, what is the place of their domicile or registration seat of NGOs. Another issue that was important with this was that this right should also be addressed to NGOs, not only to members of the public individually, but NGOs as representatives of the public interest related to the environmental protection. Then there was a very much discussion about the right to the environment. That's been a discussion for years in international law, and it ended up for most countries with a decision that establishing a substantive or subjective right to clean environment would be very difficult to be protected. However, on the other hand, it was accepted that these procedural rights could serve to protect this hypothetical right. So that was the idea that we were trying to encapsulate. So there is a mention in the convention, and if you look at Article 1 of the convention, you have it in front of you, you will see that there is a mention about the right to clean environment. However, without actually establishing such a right as a right that could be challenged at court. Another issue is a declaration that parties to the convention should promote public participation in all international processes. So it's not only what is already embedded in the convention, but elsewhere. And that's what in fact, European Union and its member states are doing globally. Whenever there is any global negotiations on whatever environmental convention, EU is always trying to promote the issues of public participation, access to information, and access to justice. Maybe to the last one to the lesser extent, but always public participation. And finally, the convention is concluded within the UNEC region. It is one of the regions of the United Nations. United Nations are divided into regions. So UNEC is the region that covers Europe, but also, as I said, Northern America and former Soviet Union. You may say white word. And separate, you have such regions for South America, for Africa, and so on. So this is not a global convention. However, we decided that it would be open also to countries from outside our region. Should any other country from outside, from other continent, would like to join us, they're welcome. And we already have started talks and they seen interest from other countries. But I will maybe later on have a moment to say a bit on this. So we have a structure of the convention is first this objective, it's the right to environment. It is not granted by the convention itself, but it's an objective. Then we have certain definitions, which are very important. Definitions of public authority, because obligations are put on public authorities. Then we have two definitions about subject of rights, public and public concerned. Then we have three pillars, operative provisions, three pillars, access to information, public participation, and access to justice. Then some provisions about meaning of the parties and provisions on the compliance mechanism. And I will talk about compliance mechanisms later on. I already mentioned the issue of right to environment, so I'm not going to dwell on this. With the three pillars, we have access to information, and here again following American invention, in fact. It was realized that the directive 313 from the 90, it covered only certain part of the issue. It covered access to information upon request, and that it's called passive disclosure. It has certain limitations. The public, in order to ask for information, must know that the information exists. And if you don't ask, you don't get information. Secondly, it was quite obvious, especially in the light of the accident in Chernobyl, you know, the nuclear accident in Soviet Union, that there are some situations whereby the public should be actively informed about certain events, that the government should actively come to the public. And finally, it was realized that it is not only about disclosing upon request the information that is being held, but it is also a responsibility of the government to make sure that they have information which is accurate, which is updated, so that it is not any information, but that they have some obligations how to keep this information also, how to make it accessible. So all of this was covered in 2 different articles. The traditional access upon request and the procedure for this, exemptions. This is all covered in Article 4. And that is what used to be from the 90s in the European Community, in the old directive. But then we have new obligations about active disclosure, and that's in Article 5. Then we have public participation. And public participation scheme is divided into several different legal regimes. The most detailed legal scheme relates to specific activities which may have a significant effect on the environment. That is the bottom of the decision-making chain, where the specific activity is being decided. Whether to build a chemical factory, whether to build a road, whether to build a dam, and so on. And what should be the allowed emission standard limit values for this particular chemical power plant. So these are specific activities. And here we have a very detailed legal scheme. But then the convention covers also, since the Almaty Amendment, GMO decisions. This scheme is not yet fully operational. I'm not going to talk about this anymore. But then what is really important is it covers public participation in the preparation of strategic decisions. And for plans and programs, we have a binding language, a bit less detailed requirements, but still quite detailed binding requirements. Then we have a legal scheme for public participation for policies relating to the environment, where there is no binding obligation. It's the word should. You know, that's a basic difference in the legal language. Shall means binding obligation, should means a recommendation, which cannot be really enforced at court. So for policies, we have less detailed and less binding requirement. And the same is for normative acts and legally binding rules, where again, it's acknowledged that there should be public participation. However, there is no binding language on this and no details. And you could easily detect this difference between the different legal regimes if you look at the binding pieces of European Union legislation. Because European Union decided that in their sphere of competence, they introduce requirements for public participation in relation to specific activities and to plans and programs. And they are not addressing so much policies and normative acts, and they leave it to member states to decide how they would like these political recommendations to accommodate. Just to be crystal clear, it does not mean countries don't need to do anything. It is still an obligation, but it's less enforceable, let's put it this way. And finally, we have access to justice pillar, whereby we address the issue that was already addressed in the old directive, that the public should have possibility to go to protect its right to environment in case of abusing its right. Secondly, its redress in case of abusing right to participate, and that's in 9.2. But after long debate, we have here a third instrument. In 9.3, we have a separate right to file a public interest lawsuit in case anyone acts, or if there is an omission, contravening the provisions of environmental law. This was again based on American invention of so-called citizen suit, whereby citizens could sue polluters. If someone is polluting not in line with the legislation, that citizens have a right to initiate legal action in certain circumstances. So that's the situation that we wanted to capture. So we are not, 9.3 is not about protecting our own right to environment, our own right to participate. It's about protecting the environment. A couple of words about development of the convention. First, in Lucca, in the meeting of the parties, it was adopted a compliance mechanism. And I will have a word on this compliance mechanism in a moment, later on, because it is very specific. Then we adopted guidelines on genetic modified organisms, and in fact it was the start of negotiations. In Kiev, it was adopted PRTR protocol, Pollutant Release and Transfer Register protocol. In Almaty, it should be 2005, sorry, that's a mistake. It was GMO amendment adopted, and the guidelines on public participation in international forum. And in Almaty, for the first time, we had first decisions concerning compliance. Then we have two other MOPs, that MOP in Riga and Chisinau, that all confirmed the approach to compliance mechanism. Before I turn to the compliance mechanism, a bit about the role of it in Europe and outside Europe. So Aarhus is the first binding international instrument which addresses comprehensively citizens' environmental rights. So now it's a benchmark and world standard. There is no other piece of legislation anywhere internationally that would do the same as Aarhus. Many international laws mentions need for public participation. Many mentions need for access to information for the public. But no other piece of international law gives the details of how to do this. So it's only Aarhus. And it gives thereby the links between human rights, democratization, and government accountability. Therefore, it is considered, and especially by the European Union, whenever the European Union is providing external aid, or whenever it's negotiating any accession, like recently with Ukraine, or even negotiations with Turkey, that is one of the first requirements. But you need to join Aarhus, because it touches upon the fundamental values of European Union: rights of the public, rule of law, democracy, and environment. They are all embedded in the treaty. So we in Europe, we considered that, first of all, environment is important for human well-being, and secondly, that it must be protected together with the people. So this is all encapsulates, and Aarhus really is in essence of this approach. Therefore, the European Union, in all negotiations elsewhere, had put this as a condition. I myself had the chance to represent, to be the envoy of European Union in some of the negotiations in some other countries, where there was clear-cut, that's the precondition. If you want to join the EU in the environment sphere, that's the first what you need to do. You can wait with your best available technology, with improving standards, because that takes money, that takes time. But you need to make sure that you have democratic principles in your environmental policy. And that's what Aarhus is all about. Maybe a bit of the role of the Aarhus. So many countries outside Europe, and many, not only NGOs, they see the merit. And there have been attempts to make it more widely applicable, not only to us in Europe. And there was an attempt to do it in Rio last year. However, it failed eventually. Many governments were not ready outside Europe, despite efforts of European Union. They were not ready to start negotiations on a global convention. That actually made a prompt initiative, regional initiative of some of the countries from Southern America, that they decided to start negotiations on their own Aarhus. They said they have a slightly different legal culture, so they need their own Aarhus. So they started not yet really negotiations, but a process leading to negotiations. And in other regions, they are considering this as well. So now we have some countries are considering from outside the region, from Asia, Africa, considering joining us in Aarhus. And in some regions, as I said, in Southern America, they decided we will try to do similar. And they seek our assistance. They need to know our experience. But they would like to do similar things for their own benefit. What is for us in Europe? EU is a party to the convention. So it is a part of the so-called acquis, of the law of the European Union. That has advantages and disadvantages. First of all, the advantage is that we have a strong enforcement from European Commission, which is a watchdog of the treaties, so they watches whether the member states observe and comply with the EU law. And eventually we have Court of Justice of the European Union, which also monitors compliance and makes sure that the law is complied. The drawback is that member states sometimes feel like being released from thinking about Aarhus because that's all done via EU law. So the difference is whether they do it themselves or they do it together in Brussels. And if they do it together in Brussels and they establish a directive or regulation, and if they happen to forget about something, that is for sure in all member states would be forgotten. And we have had cases on this in the Compliance Committee, and I will tell you later on about it. Another issue is that we have the strong compliance mechanism under the Aarhus Convention, which somehow is confronted with the internal EU compliance mechanism, which is by the Court of Justice. And we do have some instances where the Court of Justice, which is a general court, and not always understands really the nitty-gritty of the convention, gives some verdicts that attempts to interpret the Aarhus Convention not really fully in line with what it is in the Aarhus Convention. And that's a problem, but that's a legal problem. To some extent, Aarhus Convention has a direct legal, direct effect. Most of the provisions, am I supposed to finish? No, not yet. No, I said, okay. There is a general legal doctrine about the direct effect of international treaty or EU treaty. And we don't have yet clear answer about this from the Court of Justice of European Union, except for one provision, 9.3, where rightly the Court of Justice said it does not have legal direct effect. However, the court somehow indicated to the courts of the member states that they should interpret their own provisions according to this provision. In many member states, there are different approaches. The most elaborated analysis has been done by the Conseil d'État in France, which is the court, applicable court in France, and they found that many of the provisions of the Aarhus Convention should be applied directly. Now I'm turning to this compliance mechanism. During the negotiations on the Aarhus Convention, it was a clause on the compliance mechanism which was very, very vague. The reason for this was that in the negotiations participated also a couple of countries, including countries like Turkey and Russia, and they didn't want any compliance mechanism. They didn't want anyone to look on what they are doing. But eventually, they decided not even to sign the convention. So once we have a signature and the meaning of the signatories, the most fierce opponents to compliance, strong compliance, were not in. And then the rest, that was the leading role was played by the European Community, or now European Union. And here the governments, they realized that they would be under strong pressure of internal enforcers, that is the Commission and the Court of Justice. And they were a bit afraid that they themselves would need to obey the rules in the Aarhus Convention, while the other parties from outside the EU, no one would watch whether they apply or not. So they said, so we should create a mechanism that for all of these countries outside EU, someone would watch how they perform. And that was the reason to elaborate and create very strong compliance mechanism. The point is, they didn't realize, and it soon turned out after a couple of years, original cases were against Kazakhstan, Ukraine, other countries, but it soon realized that most of the cases are against European Union countries, member states. They thought, we are perfect, we have everything well done. But the public didn't share this view necessarily, and they used this opportunity to come to us. But how it was composed, this mechanism. So on top of this is the most important is the Compliance Committee, which consists of 9 independent members who are elected to serve in personal capacity, which means they are not representing governments. So that's a difference from standard environmental conventions where you have representatives of the governments. I'm in another body like this, in an OSPO convention, and I'm representing the government of Poland, which means, theoretically, that I can be instructed by my government. It never happens. They leave it up to my own judgment, what I do, but theoretically they can instruct me, you should vote this or that. In Aarhus, no one can tell us anyone. We are absolutely independent. So and also we need to have qualifications like judges. It must be lawyers with practice and track record and experience and so on and so forth. So the qualifications are like for judges. There is a regional balance. We are 9 members and we're representing 3 major regions. Old member states, new member states, and East. And the East is Caucasus, 3 countries of Caucasus, 4 countries of Central Asia, and 3 countries of Eastern Europe, Moldova, Belarus, and Ukraine. So they all can elect 1 representative. 3 countries from member states can elect 3 representatives, and the old member states also 3 representatives in the committee. The idea for this regional representation, the regional balance, is to make sure that we understand specificity of all the legal systems involved, because convention is one, but the legal systems are plenty, and we need to make sure that we more or less understand how it works. The triggers for the compliance committee, as opposed to the standard environmental convention, it's not only submission by a party for another party. It's not submission by party about itself. It's not only referral by secretariat, but also possibility of communications. Oh, that's That's by far, it's the old slide. It's already 100 now. Communication. So it could be, communication could be brought to us by any member of the public against any party. It doesn't have to be a member of the public from this country. And we have had cases where we had to, against some governments where the public was afraid of some repressions, that the communication against the government was brought by members of the public from another country. The procedure is very open. All documents are publicly available. So both the communication itself, all replies by the government, it's all available. Then we have a hearing which is open for the public, and it could be representation of both the public and the government. And then we have a draft findings, and that's like a draft verdict, and that's sent for comments, and that's unusual. And then both the communicant and party concerned can comment, and as a result of comments, we could revise our finding. So it is not once forever, and we don't, so it's a difference from the court. And what happens then? Finding could be compliance or non-compliance. And then we have recommendations for the party, what it should do, and also what the meeting of the parties should do, because the ultimate responsibility is with the meeting of the parties. And meeting of the parties can find non-compliance, but it also can impose a caution or even suspend the rights of the party concerned. And that's very unusual. We have had already some of these instances, and we are considering some of the sanctions for the governments that constantly do not follow recommendations. However, most of the governments, they accept the finding. If we find non-compliance, they accept recommendations, and they try to establish, to take all the possible measures, including changes in the legislation, to rectify situation following our recommendations. And our recommendations are normally quite very specific, precise. For example, we had for Lithuania, they had a commenting period for the public in the EIA procedure, 10 working days. And we said it's not reasonable time for industrial projects, it needs to be longer. So they changed legislation, they introduced longer time period. Okay, so that's as an introduction. I will talk a bit more about the procedure in the compliance committee, I believe, after lunch. Thank you very much.